that so I don't forget. They can see the important parts. All right, for those who are joining in on the YouTube, I've asked if everyone has proceeded, and that's the only thing that you've missed. And we're now moving forward in terms of introduction of the teams. I'll be asking in a moment if the scoring panelists have any conflicts. So I will have each of the teams introduce themselves. And if you are playing a character, if you could give both your character name as well as your scoring name. Throughout the competition, I may ask you when you're testifying to state both names for the ease of the scoring panel to be able to remember who you are, so that the right person gets the right score. So we'll start with the prosecution. If the attorneys could please introduce themselves.
Good evening, Your Honor. My name is Hollis Andrew. I will be doing the opening for the prosecution, direct examining Kyle Kuzak, and the cross-examination of Avery Becker.
Good afternoon, Your Honor. My name is Madeline Herman. I'll be doing the direct examination of Alex Cifuentes and the cross-examination of Taylor Perkins.
Good afternoon, Your Honor. My name is TJ Newman. I will be doing the direct examination of Detective Jordan Markowitz, the cross-examination of Professor Blake Van Owen, and the closing statement.
And the witnesses for the prosecution.
Morning. Sorry. Morning, Your Honor. My name is Bryn Geiger, and I'll be playing the part of Detective Jordan Markowitz.
Good morning, Your Honor. My name is Kiara Warren, and I will be playing the part of Alex Cifuentes.
Good morning, Your Honor. My name is Camille Denman, and I will be playing the part of Kyle Kuzak.
Thank you. And for the defense, if the attorneys could introduce themselves.
Good afternoon, Your Honor, members of the jury. My name is Max Seitel, and today I will be presenting the opening statement as well as conducting the cross-examination of Kyle Kuzak and the direct examination of Blake Van Owen.
Good morning, Your Honor. My name is Hayden Clausen. I will first be conducting the cross-examination of Alex Cifuentes and the direct examination of Taylor Perkins.
Good afternoon, Your Honor. My name is Marcus Winton. I will be conducting the cross-examination of Detective Jordan Markowitz. Then I will be conducting the direct examination of Ms. Avery Becker. I will also be presenting the closing argument. May our witnesses now introduce themselves?
Yes, thank you.
Good afternoon, Your Honor. My name is Brandy Mallender, and I am Taylor Perkins.
Good afternoon, Your Honor. My name is Paige Flenchy, and I am Blake Van Owen.
Good afternoon, Your Honor. My name is MJ Mintz, and I am Avery Becker.
Thank you. In terms of the scoring panelists, are there any reasons that any one of you believe that you may be biased at this point in judging in either team? And you can just turn your video or your audio on and say yes or no.
I have no issues. There are no conflicts, Your Honor.
Thank you.
I have no issues.
Thank you. All right, any dispute, and for the teams and the coaches, any disputes arising out of this competition must be reported in accordance with the competition rules. Compliance with your time requirements will be considered in scoring individual performances. And at this point, then I will be swearing in the team members, the coaches, and any other non-participating members, as well as the witnesses. So I'm going to start with the attorneys. If the attorneys could please turn on their videos and raise your right hand. I have all my attorneys. 1, 2, 3, 4. I don't see video. I'm missing 2 videos. for attorneys? There's one,
I think that's everybody.
2, 3, maybe I'm not
6
counting right.
attorneys.
Perfect. All right, team members, you've raised your right hands. Do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial presentation? Competition.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you. Witnesses, then I would ask you to turn your videos on and raise your right hands. Do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Thank you. And then gallery members, which would include coaches and teachers, and then any non-participating members. Please raise your, turn your videos on and raise your right hand. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round?
Yes, Your Honor.
Thank you. And then lastly, scoring panelists. If you could please turn on your videos and raise your right hand. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Yes, Your Honor.
Thank you. All right, with that, is the prosecution ready to present your opening statement?
First, could we begin with some preliminary matters here?
Yes, go ahead.
First, I would like to ask to constructively provide a copy of the stipulations to Your Honor and inquire whether the juries have a copy as well.
I do have a copy of the stipulations, and those are included in the case packet, and so they have been constructively provided.
Thank you. In terms of admitting exhibits, the co-counsel and I will be asking permission to screen share exhibits for purpose of establishing foundation, and then we will specifically ask to publish.
And that will be fine.
When identifying the defendant, Avery Becker, we would ask the defendant to turn on his or her camera. For purpose of identification, we will alert her when we are getting ready to do this.
Very good, thank you.
We would ask permission to stay seated during the presentations for purpose of audio-visual quality during the proceedings.
There is, for both teams, I will note that to your comfort, you may either stand or sit throughout the proceeding.
Thank you, Your Honor. And lastly, Your Honor, we would ask permission to raise our hands as we object in order to alert the court that we have an objection in lieu of standing.
And
again,
that is fine. The one thing I can tell you, and this happened a couple times yesterday, is if I'm watching, I may not see that your hand is up. Please feel free to orally state that you have an objection as well, to get my attention if I don't notice right away.
Okay, thank you, Your Honor. No.
Thank you. All right, let me ask from the defense, are there any preliminary matters?
Yes, Your Honor. First, I would like to request that all privileges that have been recently extended to the prosecution be also extended to the defense.
They are so extended.
Also, Your Honor, while each of our attorneys and witnesses have made efforts to be in a setting with the best internet capabilities possible, if at any point the court cannot see or hear us, you should feel free to interrupt us and let us know.
Will do.
Also, Your Honor, we would like to ask that all witnesses will be present for the trial today and may not be sequestered pursuant to Rule of Competition 5.3.1.
That's correct. All witnesses will remain in the courtroom.
And lastly, we would also like to request that stipulations and jury instructions be constructively read into the record.
And they are all part of the packet and constructively are read into the record.
Thank you, Your Honor. At this point in time, the defense is ready to proceed.
Very good. The prosecution then may present its opening statement.
Thank you, Your Honor. Burglary turned to butchery. A clearly planned burglary had gone wrong. Avery Becker sits in front of us here today on Zoom prepared to escape the cages of her crimes. My name is Hollis Andrew, and as the prosecutor in this case, it is my pleasure to represent the people of the state of Colorado. Avery has had a life of little struggle. She's had friends, good grades, and specifically, good skills in her mock trial club. Avery seems to be able to craft her words with ease, always able to lure the judges and scorers to her side. The only thing to revolt and rival Avery's talent was her coach, Mr. Brackman. And oh, did she dislike him. He was always telling her to prepare, always taking credit for her success, putting her on the B team. Taking credit, always. Avery, in rage, graffitied his car with permanent pens. Revenge. Something Avery had never had the likes of before. Was Avery done? No. Avery was angry. Brackman had kicked her off her teams for her outrageous actions, and yet anger dwelled too deep for remorse to matter. Avery planned on burglary. Planning to break into Mr. Brackman's house, Avery was so confident, she even informed her classmate Alex with a series of texts you can see right here.
All right, thank you. For those who are just joining us, we got kicked out and are starting back up. And so Mr. Andrew was in the midst of his opening. Whenever you're ready, sir, I appreciate your patience. So whenever you're ready, start it again.
May I restart, Your Honor?
You may.
Thank you, Your Honor. Okay. Burglary turned to butchery. A clearly planned burglary had gone wrong. Avery Becker sits in front of us here today on Zoom, prepared to escape the cages of her crimes. Avery has had a life of little struggle. She has had good friends, good grades, and specifically, good skills in her mock trial club. Avery seems to be able to craft her words with ease, able to lure the judges and the scorers to her side. The only thing to revolt and rival Avery's talent was her coach, Mr. Brackman. And oh, did she dislike him. He was always telling her to prepare, taking credit for her success, putting her on the B team, taking credit, always. Avery, in rage, graffitied his car with permanent pens. Revenge. Something Avery had never had the likes of before. Was Avery done? No. Avery was angry. Brackman had kicked her off her team for her outrageous actions, and yet anger dwelled too deep for remorse to matter. Avery planned on burglary. Planning to break into Brackman's house, Avery was so confident, she even informed her classmate Alex with a series of texts you can see right here. And here I quote, "Well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house." On March 6th, 2020, at Mr. Brackman's residence, her reunion with revenge finally came. Avery's phone had connected to the cell towers near the house, and Avery had successfully intruded into Brackman's home, planning on burglary. But Mr. Brackman's security cameras caught Avery and alerted him. Mr. Brackman armed himself with a knife, and unfortunately, in the ensuing struggles, he was killed with the same knife he introduced into the encounter. Avery had got more revenge than she had bargained for, and that's what brings us here today. Burglary turned to butchery. Me and my fellow attorneys and witnesses will show the Zoom meeting the truth of the matter. First, Detective Jordan Markowitz will tell us about the Ring video cameras, of the recordings of the Ring video cameras of Avery's burglary, Avery's texts, and also the location information of Avery's phone. Then Alex Cifuentes will tell us about the rivalry that Avery and Brackman had against each other, the graffiti Avery did, and the blatant text sent of her intentions. And finally, certified crime scene reconstruction investigator Kyle Kuzak will lay down exactly how the victim was murdered. She will show a step-by-step reconstruction of how Avery murdered Coach Brackman. No matter how much the defense twists their way through this case, or how much Avery tries to persuade you, her burglary turned to butchery. Judge, members of the jury, at the end of this case, we will ask you to find us justice and to find Avery Becker guilty of first-degree murder and second-degree burglary. Thank you.
Thank you. The defense may now present your opening statement.
Your Honor, before I begin, if I had been able to object to opposing counsel's opening statement, I would have objected to Exhibit 14, as it is evidence that has not been admitted yet.
All right, I will note that.
That's not an evidence.
Thank you. I will note that objection and do note that the rules preclude you from objecting during the opening statement. And if it is not admitted at closing, you can request that I ask the jury disregard.
Yes, Your Honor. Before I begin, can you hear and see me clearly?
Yes.
May it please the court.
Yes.
There is simply no evidence. The prosecution has no evidence tying Avery Becker to this crime. And because of this, a young woman's future is at stake, and a killer may get away. We can't change the past and bring the victim back to life, but we can bring justice to this case today. On March 6th, 2020, mock trial coach Mackenzie Brackman was found dead in his home. He had been stabbed and murdered. We agree with the prosecution about these irrefutable facts, but beyond that, the prosecution will tell you a story based on a rushed investigation that contains no evidence linking Avery Becker to this case. But you will hear the truth. You will hear from Taylor Perkins, a close friend of Avery Becker's, that the day before the murder, they were at the local fry shack playing games on their phones. Taylor Perkins will tell you that fellow mock trial teammate Alex Cifuentes could have stolen the phone. That the next day, when Avery realized she was missing her phone, she and Taylor Perkins spent the entire day looking for it, not breaking into someone's house. Next, you will hear from private investigator Blake Van Owen about how the prosecution rushed their case and how they have no evidence linking Avery Becker to this crime. Van Owen will go through the specifics of the crime scene, including the stabbing and break-in, proving that the prosecution's crime scene reconstruction was inaccurate. Van Owen will also go through in-depth cell tower data that backs up the alibi provided by Avery Becker. Finally, you will hear from the defendant herself, Avery Becker, about her relationship with her mock trial coach. Mackenzie Brackman had kicked Avery off the mock trial team, her favorite activity. And all Avery wanted to do was reconcile and get back on the team. She would never commit such a violent crime like the one she has been accused of today. All three of these witnesses will discuss Blair Rollins, another suspect in today's case who is barely investigated by the prosecution. Rollins has a similar build to that of the figure seen in the Ring video cameras, and Rollins also has a clear motive to commit this crime. These witnesses will talk about how Alex Cifuentes could have used the help of Blair Rollins to steal Avery Becker's phone and frame her for the murder. But the prosecution rushed their case and they weren't willing to look down all the alternate explanations provided by the real evidence. I'm asking you today to look for all the discrepancies in the prosecution's case, to look for all of the holes that were filled with hasty interpretations of a case that contains no evidence linking Avery Becker to this crime. You will see that neither of the prosecution's expert witnesses ever mention working with each other in their affidavits, and they even have some contradicting data. Detective Jordan Markowitz accepted unverified screenshots of possibly fake text messages and has even brought them to court today. Meanwhile, crime scene reconstructionist Kyle Kuzak lost track of key photos for their investigation. I'm certain that by the end of the day, you will see that the prosecution rushed their case to find an easy conclusion, that it shouldn't be taken seriously in any sense, because there is no evidence linking Avery Becker to the crime. Today, the prosecution holds the burden of proof. This means that to pass a guilty verdict, you, the jury, cannot hesitate in your decision that Avery Becker is in fact a murderer. But I believe that you are all just and reasonable people, and that you will see how the prosecution has no evidence linking Avery Becker to this crime. I am certain that by the end of today's case, you won't hesitate to call for the innocence of Avery Becker. It is in your hands to make the right verdict. Not guilty. Thank you.
Thank you. The prosecution may call its first witness.
The prosecution would like to call Detective Jordan Markowitz to the stand.
All right. Please state your name, including your scoring name for the record.
My real name is Bryn Geiger and Jordan Markowitz.
And what is your occupation?
I am a detective at the Denver Police Department.
And how long have you been working for the Denver Police Department?
For 13 years, and I've been a detective for 7 of those years.
And did you receive any specialized training?
I did, yes. I received specialized training in cell phone technology and forensic data recovery from the American Academy of Law Enforcement.
And what did you learn in this course?
Yes, sir. I learned how to both obtain and interpret cellular records.
And have you ever used this in cases before?
Yes, sir, I have. I've used it in over 50 cases before.
Your Honor, we would like to qualify Detective Jordan Markowitz as an expert in cell phone technology, forensic data recovery, and cell tower analysis under Rule 702.
Okay, hang on. You said that a little fast. So cell phone technology, what else?
Forensic data recovery and cell
Data
tower analysis.
Any objection from the defense?
No objection, Your Honor.
All right, she is so qualified.
What happened on Friday, March 6th, 2020?
I was called in to investigate the murder of Mackenzie Brackman, a criminal defense lawyer.
And what did you observe on arrival?
I initially observed 3 Ring doorbell cameras surrounding the residence, and then inside the residence, I observed a broken plate, a knocked over chair, blood spatters on the wall, and the victim lying in the hallway.
Your Honor, permission to share with has been marked as exhibits 1 through 4.
You may.
And what do exhibits 1 through 4 show?
Yes, exhibits 1 through 4 show pictures of the victim from inside of the residence, outside of the residence, and a close-up picture of the stab wound.
And are these images fair and accurate representations of the condition of the victim upon your arrival at the scene?
Yes, sir, they are.
Your Honor, permission to admit what is previously marked as exhibits 1 through 4 into evidence and publish them to the jury.
Any objection from the defense?
Your Honor, it appears that there are only 3 exhibits that the witness has testified to having knowledge of. I request that we be seeing, that the opposing counsel be seeing the 4th exhibit that they are talking about, and that Detective Jordan Markowitz lay foundation for how they know about this exhibit.
We are happy to simply offer exhibits 1 through 3.
All right. And so with the amendment of the request to admit 1 through 3, is there any objection from the defense?
There's no objection, Your Honor.
Exhibits 1 through 3 will be admitted and published to the jury.
Thank you, Your Honor. And then, did you see anything else upon arrival?
I did, yes. Inside the kitchen, I observed a knife drawer that was open and a knife block with a missing knife from it.
Your Honor, permission to share was previously marked as exhibits 7, 8, and 9.
You may.
Thank you. And what are exhibits 7, 8, and 9 pictures of?
7 and 8 are pictures of the knife drawer and the knife block, as I just explained. And exhibit 9 is a picture of the broken plate, as I explained earlier.
And are these fair and accurate representations of the condition of the scene upon your arrival at the house?
Yes, sir.
Your Honor, permission to admit what is previously marked as exhibits 7 through 9.
Any objection from the defense?
There's no objection to these exhibits, Your Honor.
Exhibits 7, 8, and 9 will be admitted and published to the jury.
Your Honor, permission to share what is previously marked as exhibits 5 and 6.
Yes.
What do exhibits 5 and 6 show?
That is a picture of the knife used to kill Mackenzie Brackman as seen at the crime scene and then later seen at the crime lab.
And are these fair and accurate representations of the knife both at the scene and then at the lab?
Yes, sir.
Permission to admit what is previously marked as exhibits 5 and 6 into evidence and publish them to the jury.
Any objection from the defense?
No objection, Your Honor.
Exhibits 5 and 6 will be admitted and published to the jury.
Thank you, Your Honor. And did you use the Ring doorbell in this case?
I did, yes. I used 4 different videos from 3 different cameras in my investigation.
And are you familiar with the Ring system?
Yes,
And how does the Ring doorbell work?
yes. Well, typically they are cameras set up around somebody's residence and they are motion activated
And how did you obtain those videos?
through the Cellubrite system.
And what is the Cellubrite system?
It is a system that allows me, a detective, to download data from a phone.
Your Honor, permission to share was previously marked as exhibit 12.
You may.
And what is exhibit 12 a video of?
Yes, sir. That is one of the videos I used in my investigation that shows the intruder entering the back door of Mackenzie Brackman's residence.
And can you please describe the contents of the other 3 videos that you used?
Yes, sir. Exhibit 10 is a video of the intruder coming up to Mackenzie's front door, realizing it is locked and walking away. Exhibit 11 is the intruder entering Mackenzie Brackman's back door gate, heading towards the back door. And exhibit 13 is the intruder exiting Mackenzie's front door after the murder.
Your Honor, permission to admit and publish to the jury was previously marked as, and are these fair and accurate representations of the videos you obtained from the Ring doorbell?
Yes, sir, they are.
Permission to publish or to admit and publish what is previously marked as exhibits 10 through 13 to the jury.
Any objection from the defense?
Yes, Your Honor, I have several objections. Number 1, I would object more prejudicial than probative, relevance, and I would object more prejudicial than probative and relevance. The disguised intruder is in fact wearing a disguise. This means that it does not go to disprove an issue in today's case. There is no dispute on whether or not Mr. Brackman's home was broken into. The dispute is whether or not it was Miss Becker who broke into Mr. Brackman's home. Because Detective Markowitz never brought forth evidence that Miss Becker was in possession of such a disguise, this does not go to prove nor disprove whether or not Miss Becker broke into Mr. Brackman's home. Therefore, it is irrelevant, and it is also more prejudicial to the jury than its probative value warrants.
Your Honor, may I respond?
Yes.
First, as to the relevance, I believe it is relevant to understand the actions that took place and the order of events that took place at the scene of the murder. And then as to its value outweighing its prejudicial value outweighing its probative value, as you said, it is the intruder is disguised, so this cannot prejudice the jury in any way for or against my client or for or against your client, because it is simply there to its probative value is to show the jury how the events of March 6th happened.
Any further
Your Honor.
response from the defense?
Yes, Your Honor. As to the relevance, this is still irrelevant as it does not go to prove nor disprove an issue in today's case. There is also no timestamp on the video, so we further have no idea when this video was actually taken. Therefore, it does not help to prove nor disprove any issue in today's case. As for the more prejudicial than probative value, I anticipate that Detective Markowitz will testify that the intruder matches some physical aspects of Miss Becker, and the prejudicial value of that is substantially outweighs any probative value.
And the issue of the timestamp, Mr. Newman, is a new one, and so I'll allow you to respond to that if you wish.
Yes, we've just heard testimony from the witness explaining how they obtain. I can lay more foundation as to how they obtained the videos and how they knew that it was from what time the videos were taken, if that would alleviate that concern.
Anything further from the defense on these arguments?
The foundation for when the videos actually took place cannot be laid, as nowhere on the video itself is there any timestamp. Therefore, the detective cannot lay the foundation for when these videos were in fact did in fact take place.
I don't find that there's any requirement that the video or a photograph or any other type of evidence have a timestamp in order for it to be authenticated. The testimony in terms of the from the detective relates to the time when it occurred, and so therefore enough foundation's been laid for that date. In terms of the videos being more probative, more prejudicial than probative, I do find, as the prosecution has argued, that the fact that this is related to the specific events in the break-in does relate to that, and it's not prejudicial because it doesn't identify anyone in particular. That goes more to the weight that the jury should give it rather than its admissibility, and for reasons it would also be relevant. And so the objections are overruled, and exhibits 10 through 13 will be admitted and published to the jury.
Thank you, Your Honor.
Yes, Your Honor.
And just for the jury, here is the video. All right. And Detective Markowitz, what was the major break in this case?
Yes, sir. After some investigation going through old emails, I figured out that Mackenzie Bracken was the coach of something called mock trial at Colorado High School. And then got in touch with the high school and then got in touch with some of the students on the mock trial team from the previous year, including a student named Alex Fuentes.
And what evidence did Mrs. Cifuentes give you?
Alex Fuentes provided me screenshots between her and another student on the mock trial team named Avery Becker, saying that Avery Becker was going to come to Mr. Brackman's house and trash it after being kicked off the mock trial team.
And what are call detail records?
Call detail records, it is a record that is created when a call or text goes through a cell tower.
And what can these records provide to a investigator?
They can tell if a call is incoming or outgoing, the date and time of the communication, what cell tower and antenna it went through, and who the sender or recipient is.
And can these antennas give a rough location of a phone?
Yes, they can.
And how do these antennas give that rough location?
Well, a given antenna only covers a certain area. So when a cell phone makes a connection with that antenna, you can predict that the phone is near that antenna.
And were you able to use this information to place anybody at the scene?
Yes, I was. I was able to use CDRs or call detail records to place Avery Becker's phone at the scene.
And how did you do that?
I looked at the cell tower data, the cell detail records, and on Avery's phone, and it made 3 connections during the time leading up to the murder, one being at the cell tower closest to Mr. Becker's house, the next one being on a route that Mr. Becker likely took to Mr. Brackman's house, and the third one being at the tower closest to Mr. Brackman's house.
Your Honor, permission to share was previously marked as Exhibit 16.
You may.
Thank you. And what is Exhibit 16?
Those are the 3 cell towers that Mr. Becker's phone made connections with during the time leading up to the murder.
And what is the blue dotted line?
That is the likely route that Mr. Becker took to Mr. Brackman's house.
Thank you, Your Honor. No further permission to admit was previously marked as Exhibit 16 and publish it to the jury.
Any objection from the defense?
Yes, Your Honor. The defense would object more prejudicial than probative and hearsay. The prejudicial value is because it is the defense's opinion that Miss Becker was not in fact in possession of her phone. And since the call detail records cannot definitively say whether or not Miss Becker was in possession of her phone, nor can they even give a precise location of her phone, only the cell tower that they connected to, it substantially prejudices the jury against my client, Miss Becker. And as for the hearsay, both the line that Detective Markowitz drew, as well as all of the landmarks, including the locations and street names, are all out-of-court statements being used to prove the truth of the matter asserted.
Response from the prosecution.
Okay, well, first, as to it being more prejudicial than probative, I feel that this case is largely based on the identity of the killer and the probative value of showing that a cell phone, the probative value of placing the killer at the crime scene substantially outweighs its prejudicial value. And then as to hearsay, I do not understand how the locations and landmarks of things are hearsay.
Anything further from the defense?
Yes, Your Honor. Again, because the call detail records cannot pinpoint even where the phone was, it can only tell which tower is connected, and it cannot definitively say whether or not Miss Becker was in fact in possession of her phone. This substantially prejudices the jury. As for hearsay, the statement would be the landmarks, such as Mr. Brackman's home or Miss Becker's home, and the truth of the matter asserted being that that in fact is where those places are, as well as the line that they claim the route that Miss Becker took.
In terms of the hearsay objection, there's no declarant that is making the out-of-court statement, and so therefore I don't find that it's hearsay. Second of all, in terms of whether or not the evidence is more prejudicial than probative, the evidence is being presented that it is the location of the cell phone, not the location of the person. And so whether or not it would indicate the presence or non-presence of the defendant is evidence that can be presented, and then that would go to the way that this would be admitted. I find that it's the foundation has been laid, and so therefore the Exhibit 16 will be admitted and published to the jury.
Thank you, Your Honor. No further questions.
Thank you. Defense, you may start your cross-examination when you're ready.
Give me just one moment to adjust my camera.
That's fine.
Good afternoon, Detective Markowitz. You just talked an awful lot about all the conclusions you came to in this investigation. So let's talk about some of these conclusions. There was no DNA?
No, sir. In a case like this, there's rarely DNA, plus the intruder was wearing gloves.
So as a yes to my question, there was no DNA evidence?
No, there was not.
Objection, Your Honor.
There were no eyewitnesses.
Hang on one second. Are you objecting to the second question?
Yes, Your Honor.
I don't find at that point that it had been asked and answered, but I'm not sure what the next question is going to be. So the objection's overruled, but continue with your next question.
There were no fingerprints found at the scene of the crime?
No, like I said before, the intruder was wearing gloves, and there are rarely fingerprints in a case like this.
So that's a yes to my question. There were no fingerprints.
No, there were not.
There were no eyewitnesses, yes or no?
No, there was not.
So you claim that the Ring video camera was evidence that Ms. Becker broke in. Is that correct?
Yes, it was.
But we can agree that the suspect was wearing a disguise.
Yes, the suspect was wearing a disguise.
And Ms. Becker wasn't in possession of such a disguise?
Miss Becker likely threw away the disguise after committing the crime.
Is that a yes or a no to my question? Is that a yes or no to my question?
Avery Becker's not currently in possession of a disguise like that, no.
You didn't even look at her residence to see if she was in possession of such a disguise, did you?
No, I did not. Like I said, she would have likely got rid of it.
So you didn't even bother looking, is that correct?
That is correct, because it did not seem relevant.
And as for the timestamp, the video doesn't have one, does it?
No, it doesn't, but you can roughly see when it was.
So you have no idea what time exactly this video was taken, do you?
Not exactly, no, but I can make an estimate.
Now, moving on, let's talk about the investigation that led you to these conclusions. You claim that the biggest break in your case was talking to Alex Cifuentes. Is that correct?
That is correct, yes.
However, you interviewed Avery Becker and Ms. Taylor Perkins before you interviewed Alex Cifuentes?
No, I tried to interview Avery Becker after interviewing Alex Fuentes, but Avery Becker would not allow me.
So is it your statement here in court today that you never interviewed Ms. Avery Becker?
No, I did not, as Mrs. Becker refused to meet with me.
Now, moving on, you were sent screenshots by Mr. Alex Cifuentes, is that correct?
Yes, I was. I was sent 2 screenshots from Alex Fuentes.
But you never used the Cellbrite system you talked about to examine his phone directly, did you?
No, I did not. Alex Fuentes, unfortunately, did not bring his phone.
Objection, non-responsive. I have asked a properly framed yes or no question, and the witness has gone far outside the scope of that question.
Any response from the prosecution?
Yes, Your Honor. The witness was providing relevant context to her answer. I think she was well within the scope of the question.
Your Honor, may I respond?
You may.
As this is a timed competition, if the witness would like to provide all the context that she would like on her own time during redirect examination, that would be just fine. However, the rules of competition do require that she answers as succinctly as possible.
I am sustaining the objection in terms of that the answer has been requested for a yes or no, and so that should be the answer, and further questioning could be, if context is needed, can be accomplished on redirect.
I ask that the last part of her testimony be stricken from the record.
And I will strike that testimony.
Yes, Your Honor. So you never directly searched Mr. Cifuentes' phone, is that correct?
That is correct, yes.
You never even asked him to bring in his phone to be analyzed.
No, not after receiving the screenshots.
Now, let's move on to Blair Rollins. You knew that Blair Rollins was a suspect in today's case?
I'm familiar, but not, yeah.
Is that a yes or a no to my question?
Yes, it's suspect.
But you never attempted to find Mr. Rollins, did you?
No, I did not, as my evidence was substantial enough.
So that's a yes to my question. You did not make an attempt to find Mr. Rollins?
No, I did not.
You never searched his residence?
No, I did not, as it was not necessary.
You never...
Objection, Your Honor, lack of personal knowledge. The witness does not have personal knowledge about Blair Rollins. How can she testify as to what Blair Rollins did or did not do?
Well, the question, I'm sorry, go ahead and respond if from the defense.
Your Honor, as Detective Jordan Markowitz has been tendered as a detective, it is well within her knowledge to know who in fact would have been a suspect, and it would be proper police procedure to search the residence of such a suspect. I'm simply asking her if she did that for the suspect Blair Rollins, which is well within her knowledge.
Any further response from the prosecution?
No, Your Honor, I stand by my objection.
I am overruling the objection. The questions are related to the actions taken by the detective, and so therefore within the knowledge of the witness. Continue with your
Yes.
cross-examination.
So you never searched his residence, yes or no?
No, it was not necessary.
Now, let's talk about Ms. Becker's phone. You claim that her phone was at Mr. Brackman's home.
Yes, the call detail records show that.
Call detail records don't give a pinpoint location of a device, is that correct?
They give a rough location.
I'm sorry, you must have misunderstood my question. Yes or no, do they give a pinpoint location of a device?
Not a pinpoint, no.
So do call detail records explain, or excuse me, do call detail records determine whether or not a person was in possession of her phone?
No, they do not.
So you have no idea if Ms. Becker was in fact in possession of her phone?
No, I do not, but it seems kind of coincidental, doesn't it?
Now, let's talk about Ms. Becker's alibi. You never looked into her alibi?
No, I did not.
You never looked at mall footage?
No, I did not.
You never looked at Fry Shack security footage?
No, I did not, as it was not necessary or relevant.
You're claiming that it was not relevant to look into the suspect's alibi?
No, as the call detail records placed Avery Becker's phone at the crime scene.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor. Detective Markowitz, do you think it would be a valuable use of police time to go hunt down asinine leads after you have found a strong suspect?
No, I did not. After all of my evidence strongly pointed to Avery Becker being the suspect, I did not feel I needed to follow up on other irrelevant suspects.
And do you believe that within your, there no further questions, Your Honor.
All right. Thank you. The prosecution may call their next witness.
The prosecution calls Alex Cifuentes to the stand.
Please state your name, including your scoring name for the record.
My name is Kiara Warren, and my do you want me to spell my last name?
That's fine. Yes.
Okay, Warren.
Thank you.
And I am playing Alex Cifuentes, Sifuentes.
Whenever you're ready.
At this time, we ask that the person playing Avery Becker turn their camera on for purposes of identification.
Would you please do so? Thank you.
Mr. Fuentes, who is Avery Becker?
Avery Becker is a classmate of mine, or was a classmate of mine, and was also a teammate on the mock trial team.
And what is your relationship with Avery Becker?
Avery Becker was my best friend. I mean, she even got me into mock trial.
Do you see Avery Becker in court today?
Yes, I do.
What are they wearing?
A white shirt with a black overcoat.
Your Honor, let the record reflect identification has occurred.
The record will so reflect.
And what was your relationship to Mr. Brackman?
Mr. Brackman was my mock trial coach and, well, my role model.
And would you say that your mock trial team does pretty well?
I would, yes. We've won some awards.
Would you mind listing them?
Yes, last competition at regionals, Avery Becker won an award for best attorney and best closing argument.
And overall, have there been any incidents regarding work ethic of the team?
There have been quite a few, unfortunately.
Could you give us an example?
Yes, there was one main event that stuck out where Mr. Brackman and Avery were getting into an argument about Avery's lack of preparation.
And what happened?
Mr. Brackman ended up kicking Avery out of practice.
And what did Avery do when she got kicked out?
She grabbed a permanent marker off of the easel that we had been writing ideas on.
And what happened after that?
I later found out that she had written Worst Attorney Award on Mr. Brackman's car.
And was the vandalism done in permanent marker?
Yes, it was.
Have those permanent markers been used before?
Yes, we use them all the time at practice.
Could you tell the difference between a dry erase marker and a Sharpie?
Yes, quite easily.
Moving on. After Avery was kicked off the team, did any form of communication happen between the two of you?
Yeah, Avery ended up texting me asking if I could help her get back on the team.
And were you sure that the number you received the text message from was Avery Becker's number?
Yeah, they said so in the text, and the contact also told me it was Avery.
And would you ever steal something?
No, never.
Would you ever steal someone's phone?
No, and I wouldn't have stolen Avery's phone. I mean, Avery was my best friend, and Mr. Brackman was a great coach that I admired. I would never do anything to put either of them in danger.
And when Avery texted you, did you discuss the car incident at all?
We did. I told her that Mr. Brackman was still mad about it, and I didn't think she'd get back on the team.
And what did Avery say in response to this?
She said something along the lines of, if he didn't like that, wait till he sees what I do to his house.
Were you asked to show these text messages to the police?
I was. I sent them screenshots.
Your Honor, permission to share my screen with what has been marked as Exhibit 14.
You may.
Do you recognize these?
Yes, I do.
And what are they?
Those are the screenshots of my text message or my text conversation with Avery that I sent to the police.
And who took these pictures?
I did.
Do they accurately represent the pictures you took that day?
Yes, they do.
Your Honor, I move to admit Exhibit 14 into evidence and publish it to the jury.
Any objection from the defense?
Yes, Your Honor. I have multiple objections. May I proceed?
You may.
My first objection is pursuant to Rule 801 hearsay. Both the contact name at the top of these screenshots and the statements within are both hearsay. Because of the fact that we have the contact name Avery Becker, it's going to prove the truth of the matter asserted, which is that Ms. Becker wrote these messages. And within these messages, we also have, within the messages sent from who is presumed to be Avery, they're going towards the truth of the matter asserted, which is that Avery intended to break in. My second objection is pursuant to Rule 1003, admissibility of duplicates. Now, because these are screenshots, what the rule states is that duplicates are admissible, such as screenshots, unless a genuine question is raised about the authenticity. Now, the defense has said that Avery Becker did not write these text messages, and so since a genuine question has been raised, it would not be admissible. Also, under Rule 1002, this cannot be best evidence, as these did not come directly printed from the phone themselves.
May I respond?
You may.
In response to the hearsay objection, these are statements by party opponent under Rule 803D2. And in response to the best evidence rule, under Rule 1001, a original or a photograph means a photographic image or its equivalent stored in any form.
May I respond, Your Honor?
Hang on one second. Did you have, I just want to make sure that, did you have a chance to review the best evidence? There was the last objection. Was there any response to that?
Rule 1002 or 1003?
I
heard
1002.
1002. In response to 1002, if you look at 1003, it says a duplicate is admissible, and I know the question of the exhibit's authenticity was arise, but this comes in under Rule 901 because it is a witness with knowledge, as Alex Cifuentes was the one who received these text messages and sent them.
Thank you. Yes, now the defense may respond.
Responding to the 801D2 hearsay exception, We still do not believe that these messages were actually written by Avery Becker, which also leads into the 901 response. Even though Ms. Fuentes can theoretically often authenticate these messages, we still do not believe that it was Avery Becker who wrote them.
Thank you. In terms of the hearsay, well, let me start with the authenticity objections. In terms of the best evidence, and this being a photograph, the best evidence in this case, because these are text messages that would be on a phone, would be the phone itself. However, due to the nature of the text messages and the authentication that's been provided by Ms. Fuentes, that this was Avery Becker's phone number, I do find that the foundation for authenticity has been laid, as well as the fact that the duplicate correctly identifies that document. The evidence can be presented that whether or not Ms. Becker had provided this information, and that would go to the weight to be given to it. As to the content of this document, it being hearsay, these are statements by a party opponent in terms against interest. And so therefore, I do find that the hearsay exception has been met. And so the objections are overruled. Exhibit 14 is admitted and published to the jury.
Thank you, Your Honor. And Mr. Fuentes, who is Blair Rollins?
I think Blair Rollins used to go to CHS, but I'm not sure. I didn't really know them well.
So do you have a meaningful relationship with them at all?
Not at all, no.
Is it safe to assume that you would not have contacted Rollins during this case?
No, I haven't.
Lastly, why are you testifying against Avery Becker when you have mentioned your friendship?
Avery Becker was my best friend, so it pains me to have to do this. But if being a part of mock trial these past few years has taught me anything, it's that justice needs to prevail and the truth has to come out, or else more people will lose their teachers, friends, and their role models like this. And that's wrong.
Okay, no further questions, Your Honor.
Thank you. You may begin cross-examination whenever you're ready.
May I request just a moment to reposition my camera and stand?
Yes.
Thank you. Now, Your Honor, before I begin, can you see and hear me okay?
I can, thank you.
And if at any point I cut out, please feel free to interrupt me.
Thank you.
Good afternoon, Ms. Fuentes.
Good afternoon.
Now, from what you saw, Ms. Becker never had to put a lot of effort into mock trial, did she?
No, she didn't.
And you always put in your best work, didn't you?
Yeah, I prepared very hard for every session.
And it irked you when you had to do this and Ms. Becker wouldn't put in any work, didn't it?
I mean, we all have our own ways of competing. It didn't really irk me what she did too much unless it came to the competition.
And you had a lot of respect for Mr. Brackman, didn't you?
Yes, I did.
And on direct, you even stated that he was like your role model. Isn't that right?
He was, yes.
And you believe that Ms. Becker never showed any respect to Mr. Brackman. Is that correct?
I don't believe I've said that.
And did you ever state that you believe that there wasn't enough respect given between the alleged pranks that were pulled or even her work ethic through mock?
Yes, there wasn't enough respect, but there could have been times where she showed some. I'm not sure.
And when Ms. Becker got a Best Attorney award, it felt like a slap in the face. Is that correct?
Yes, it is.
And she had always gotten the awards that you believed others or even you deserved?
Yes.
And when she had left the team, you were quite excited for the larger roles that you could have with her gone, weren't you?
Partially, but it also could have meant that we weren't going to be able to make it to states.
And you claim Miss Becker knew exactly what she was doing when she picked up that pen and wrote on the car in permanent marker. Is that correct?
I believe so.
And you claim Mr. Brackman rightfully demoted Avery to the B team. Yes or no?
Yes.
And earlier on, you had told the jury that Miss Becker reached out to you about getting back on the mock trial team. Is that right?
Yes, she did.
Your Honor, let the record reflect that my trial technician is currently displaying Exhibit 14, which has been previously admitted into evidence.
All right.
Mr. Hernandez, thank you. And you claim that Miss Becker became enraged when she realized that she was not going to be let back on the team. Is that correct?
Yes.
And you no longer have the phone that you received these texts on. Is that correct?
That is correct.
And you had sent in these screenshots to Detective Markowitz a full 3 months after the murder when she had requested them?
Yes.
And thank you, Mr. Hernandez. You may now take down the exhibit. Thank you, Your Honor. No further questions.
Thank you. Any redirect from the prosecution?
No, Your Honor.
Thank you. The prosecution may call its next witness.
The prosecution calls Kyle Kuzak to the stand. Please state your name and spell it for the court.
My name is Camille Denman, and today I will be portraying the role of Kyle Kuzak, K-U-Z-A-K.
Where do you work?
I work for the Denver Police Department in Denver, Colorado.
And what is your occupation in that?
I am a crime scene reconstruction investigator.
And what are your job duties?
I investigate complex crime scenes such as home invasions, burglaries, homicides, and fatal accidents, etc. My job as a crime scene reconstruction investigator is to reconstruct the crime scene in order to determine what happened. My job, I would like to clarify, does not involve determining a suspect unless it is very obviously a part of the reconstruction process.
And how long have you been investigating complex crime scenes?
I have 19 years of experience as a crime scene reconstruction investigator, or CSR for short, and the most recent 3 years of my tenure, I've been a CSR for the Denver Police Department.
And are you a police officer?
I'm not. I am a civilian employee of the Denver Police Department.
Do you have any certifications?
Yes, I am certified by the Colorado Board of Investigation in crime scene reconstruction.
Your Honor, at this time, I tender this witness as an expert in the field of certified crime scene reconstruction investigation under Colorado Rule 702.
Any objection from the defense?
There is no objection, Your Honor.
All right, she is so designated.
What are the duties of a CSR?
I investigate evidence from a crime scene in order to create an accurate and scientific reconstruction.
Okay. Were you assigned to investigate the crime scene of the homicide that occurred at 444 Flower Street?
Yes, I was.
And did you visit the crime scene?
I did.
And what, if any, evidence did you review in this case?
I reviewed a lot of evidence in this case, although I wish there were more. I always wish there was more evidence for every case I investigate. I viewed photos from the crime scene, I watched the ring security videos, I read the autopsy report, and I visited the crime scene.
Turning to the photographs, what specific photographs did you view?
I viewed photographs of a broken plate, scuff marks, the victim and his body from various angles, the photos of the blood spatter and blood droplets.
And were the photos of the blood droplets and cast-offs intact when you viewed them?
They were. However, it is my understanding that they became partially corrupted well after I had finished my investigation, and my investigation was hindered in no way by the corruption of the photos.
And were they intact when the prosecution viewed them?
The photos of the blood droplets were not intact, unfortunately, as that might have helped the prosecution to come to a stronger conclusion. The evidence provided in the photos of the blood droplets is essential to this case, and when the prosecution was lacking this evidence, it is a major hindrance to their investigation.
And turning back to the photographs, what did the photographs reveal?
The photographs of the blood spatter revealed a clear chronology in which the victim was stabbed near the kitchen table. And then there was a series of smaller blood droplets towards the front door where the victim was recovered. There were larger pools of blood and the knife. Additionally, there was blood spatter on the wall and the ceiling, which was consistent with my theory that the victim pulled the knife out of his own back near the front door.
Your Honor, permission to share what has been previously marked as Exhibit 19.
You may.
Was there an autopsy created in this case?
There was.
And were you given this autopsy?
Yes, it was essential to my investigation.
And who created this autopsy?
This autopsy was made by the City of Denver medical examiner, Mel Robbins.
And as a crime scene reconstruction investigator, did you rely upon this autopsy to reach your conclusion?
Yes, in this case, as in many cases, the autopsy was essential to my investigation.
And is this a fair and accurate copy of the autopsy report of Mackenzie Brackman?
Yes.
Your Honor, I move to admit Exhibit 19 into evidence.
Any objection from the defense?
There is no objection, Your Honor.
All right, Exhibit 19 will be admitted and published to the jury.
What was the cause of death of the victim?
The victim died of exsanguination after he bled out from his thoracic aorta in his left shoulder.
And was there any evidence, or was there any DNA or fingerprints found at the scene?
There was not, but that's very common for these types of investigations.
And were you able to reach any conclusions about what happened in this case?
Yes. By watching the ring security camera footage, I was able to conclude that a perpetrator matching the general height and build of the defendant approached the front door, entered by the front porch and tried the front door before heading around towards the south side of the house and eventually entering through a sliding door.
And what did you conclude happened as the perpetrator entered the home?
Yes, there are a variety of ways in which Mr. Brackman might have been alerted that there was an intruder. First of all, he might have heard any of the various alerts on his phone from his ring security system. Or he might have heard someone approaching his house, opening the door, or walking across his kitchen. Regardless, Mr. Brackman armed himself with a knife, which he got either from a drawer in his kitchen or from a knife block, as the knife block was missing a large chef's knife, which ultimately would be similar to the large chef's knife recovered from the crime scene, and armed himself in preparation.
And what did you conclude happened once the perpetrator, and what happened next?
The perpetrator and the victim involved in a struggle after the victim entered the house, and resultingly, the perpetrator somehow gained possession of the knife and stabbed Mr. Brackman from a bear hug type position in which he reached around and stabbed him in his shoulder.
And one more question. What is your opinion on Blake Van Owen's opinion in this case?
I am familiar with Professor Van Owen's theory, and I think it is preposterous. First of all, his theory is based on an investigation which was missing crucial evidence. Second of all, his theory would have required the victim to have been surprised, which, as I previously outlined, is highly unlikely, as there are many ways in which he might have been alerted. Additionally, Van Owen's theory does not Van Owen's theory does not account for other key pieces of evidence obtained from the crime scene, such as a broken plate and scuff marks, which, although they may seem irrelevant at first glance, they are just continual indicators that there was a struggle.
Thank you. No further questions, Your Honor.
Cross-examination. Oh, I'm sorry. What's your objection?
Before I begin my cross-examination, the previous statements about Professor Van Owen are lack of foundation and hearsay, because first, Van Owen has not released any statements today in court. So far his statements are out of court statements. Also, there's lack of foundation as not enough evidence has been laid for the speculation that has been given by Ms. Kuzak.
Response from the prosecution.
May I confer with my co-counsel?
Yes.
Thank you. I am ready to respond, Your Honor.
All right.
Kuzak is an expert and is able to testify their own opinion under Rule 702. And also, there is no hearsay involved in this statement.
Any further response from the defense?
As to Ms. Kuzak being an expert, she has been recognized as an expert in crime scene reconstruction, but testifying to the statements of Van Owen, which have not been clearly stated, besides one broken plate, still lack of foundation to the speculation that her investigation was preposterous.
I do find that an expert can give an opinion in terms of another expert's opinion and rely on hearsay based on those opinions. And so therefore the evidence and the testimony is proper expert testimony, opinion testimony, and the objection is overruled. Whenever you're ready, sir, you may begin with your cross-examination.
Before I begin, can I briefly reconfigure my camera?
Of course.
Hello, Ms. Kuzak.
Hello.
Let's start with the beginning of the crime. You testify that Mr. Brackman was aware of the intruder?
Indubitably.
And that he was alerted by his Ring camera system?
He might have been alerted by his camera system or by various other factors, including hearing someone enter his home.
So we don't know if the Ring camera system had notifications turned on?
We do not know that, but it is plausible to assume that one would have their Ring notifications on, as it is a security system, and it is also plausible to assume he might have been alerted in another way.
We don't even know, however, if he saw a Ring notification.
Again, he might have been alerted in another way.
But you didn't investigate his phone. In fact, no one in the prosecution investigated his phone to see if specifically Ring notifications were turned on.
Based on my investigation and the evidence at the crime scene, it is obvious, it is blatantly obvious that Mr. Brackman was alerted, either by his camera or by other factors.
But to answer my question, you or anyone else in the prosecution did not check his phone to see if Ring notifications were turned on.
That is correct. His notifications were irrelevant, as it was obvious that he had been alerted.
But a Ring notification could have given us a timestamp for the video, correct?
Yes, I suppose.
So you are saying that the timing of the break-in was irrelevant to this case?
The timing of the break-in is relevant, as it indicates that this was clearly a burglary which turned to a murder, as the perpetrator entered the house at an hour, which is not disclosed in my case materials, in which the victim likely would have been outside.
Objection, Your Honor. Non-responsive. I have been asking multiple yes or no questions to Ms. Kuzak, and she has gone far outside the scope of these questions.
Response from the prosecution.
I would also like to object because he did just cut off my witness while they were speaking.
All right. So do you want to respond to his objection first?
Yes, Your Honor. She had
Actually, I'm sorry. I meant for Mr. Andrew. I meant for him to respond to that, and then I'll allow you to do that.
Oh, okay. Yes, Your Honor.
My witness is simply explaining her response.
All right. And so then you may respond to the objection by prosecution.
I was cutting off this witness because she had already answered my question. And if she wishes to explain her question further, she can reserve time to do that during redirect.
I am sustaining the objection from the defense related to non-responsive to the question. If there's a yes or no answer that's required, that is the answer to be given, and certainly more context or information can be asked on redirect. In terms of it being cut off, typically I would agree that can be an issue, but in this instance, since the questions were being answered beyond what the question had required, I do find it was appropriate and it was not unprofessional, and so I am not going to take any further action on that. So if you wish to re-ask your question, sorry, you can do that.
Yes, Your Honor. And can her previous answer be stricken from the record?
Yes, only to the last question asked, since that's the last objection.
But again, Ms. Kuzak, you never investigated whether there was a notification, so we don't actually know when the break-in took place.
That is correct.
Moving on, you believe that the intruder gained the knife, the murder weapon, from Mr. Brackman in a struggle, correct?
Yes.
But you barely have any clear evidence to this struggle.
There's plenty of evidence.
Well, let's talk about the scuff marks that you have cited in your direct examination and in your affidavit. You were never able to clearly date when these scuff marks were made.
That is correct.
And you were never able to determine exactly how the scuff marks were made.
That is correct.
Moving on, you mentioned that your job as a CSR rarely entails specifying certain suspects for the case.
That is correct.
Your Honor, at this time, I wish for my trial technician to display Exhibit 17 for the purposes of identification.
May do so.
Ms. Cusack, you recognize this exhibit, correct?
I do.
And it is fair and accurate to the best of your knowledge?
It is.
In this exhibit, you mention 3 suspects, correct?
Yes, this exhibit is completely, entirely objective and was created for the purpose of organizing objective evidence obtained from interviews with witnesses.
A moment, I think there's an objection. Go ahead.
This exhibit calls for hearsay under Rule 802.
I think.
Can I respond?
You may.
Your Honor, this is not hearsay, as it is not being used to prove the truth of the matter asserted. It is being used to compare 2 different statements that have been provided by Ms. Kuzak.
Any other response, Mr. Andrew?
I stand by my objection.
I am overruling the objection. This, as I understand it, is the report made by the witness, and as the basis of the opinion, I will allow testimony from it.
Yes, Your Honor. Ms. Kuzak, you never mentioned any of the suspects mentioned here in your affidavit, correct?
Can you please repeat the question?
You never mentioned in your affidavit any of the 3 suspects that are mentioned in this document, correct?
That is correct.
let's talk about one specific suspect, Blair Rollins. Do you know the current whereabouts of Blair Rollins?
I do not. I have not investigated Blair Rollins. That is.
I'm sorry, there's another objection.
I would like to, I would like to object to the questions relating to Blair Robbins under 7 or under Rule 701, it is an improper lay opinion because they are not experts about suspects.
Any response from the defense?
Your Honor, Ms. Kuzak has already mentioned that Blair Rollins is a suspect in this case, and I am simply asking her for the current whereabouts of Blair Rollins, which do not fall under any certain expertise. It's just a common fact of knowledge that I'm asking if she has.
Any further response?
It also calls for a lack of personal knowledge.
The question itself, I'm going to overrule the objection. One, in terms of the lack of personal knowledge, if she doesn't have personal knowledge, she can answer to that. In terms of the question that's being asked is not an opinion, and so therefore I am overruling the objection based on the information provided by the witness. So the objection's overruled. You may continue with your questioning.
May I re-ask the question, Your Honor?
You may.
Ms. Kuzak, do you know the current whereabouts of Blair Rollins?
I do not. I am not familiar with the portions of the investigation involving Blair Rollins.
Do you know of anyone that knows do you know of anyone who knows where Blair Rollins has been since the day of the murder?
It is unclear in my witness statement whether or not I interviewed the other witnesses. So I will say that I am not sure.
Moving on, you compare the height and size of the intruder to that of the defendant for your reconstruction, correct?
That is correct.
But you've never seen the defendant, Ms. Becker, in person, and you've never received photographs of her from the police, correct?
I am familiar with her height and dimensions, and they are similar to that of the intruder.
But you've never received any photographs of her from the police?
I don't know.
You do not know if you've received photographs of the defendant?
Based on the information provided in the case materials, I do not know if I have been in contact personally with the defendant or whether I received photos of her.
And finally, you never used the height and size of the intruder and compared that to the height and size of the victim and factored that into your reconstruction of the stabbing, correct?
That was not relevant to my investigation. My conclusions have all been blatantly obvious from the evidence.
I'm sorry. The size of the intruder was not relevant to the stabbing itself?
Sorry, what's your objection?
On the last question, he cut off my witness.
Well, and I think he tried to let her. Did you have the chance, ma'am, to finish your answer?
Yes, I did.
Okay, I'm sorry. Thank you. Go ahead.
You're saying that the size of the intruder is not relevant to that of the murder case?
The size of the victim, I didn't measure the size of the victim because I'm a crime scene reconstruction investigator. And whether or not the medical examiner chooses to put the size and dimensions of the victim in his report has no relevance to me. So I cannot testify to that.
So to answer my question, you do not believe that the size of the murder is relevant to the murder case itself?
I don't know. My investigation includes all relevant details.
And finally, you mentioned some blood splatter during your direct examination, correct?
That is correct.
And there was blood splatter all over the house in different areas that helped you make conclusions about the crime scene, correct?
That is correct. I relied heavily on the evidence provided by the blood spatter.
But you have lost the photographs of this key evidence.
I did not lose the evidence personally. I used the evidence well before it was corrupted, and it did not affect my investigation in any way.
But the defense expert will not be able to see these photographs.
Unfortunately not, and I believe that that provides a major hindrance to his case as the only detective or investigator on the defense as a defense witness.
And the jury will not be able to see the photographs of this important information.
Unfortunately not, but I have testified to their content.
Thank you, Ms. Kuzak. No further questions.
All right, any redirect?
Yes, Your Honor. Do you believe that the victim was notified of the perpetrator's whereabouts?
I believe that it is obvious from the evidence at the crime scene that the victim was alerted in some way of the perpetrator's presence.
And what are your opinions on the scuff marks that were found in the house?
The scuff marks, although perhaps their dating cannot be proven, they are present in the house, and they additionally prove my theory that there was a struggle in the house in addition to other evidence which already proves that.
And once again, will you tell us what your job is as a CSR?
My job as a CSR is to reconstruct the crime scene. My job, which is different than Detective Markowitz, who has already testified to how the suspect was determined, is not to determine a suspect unless it is obvious from the evidence at the crime scene. The evidence obtained elsewhere of the cell phone records, I'm not qualified to speak about that because I'm not certified in cell phone records as an expert. So my job's not involved that.
And do you measure the size of suspects or victims? Is that in your job?
I don't know.
Okay. Were the pictures of the blood splatter intact during your examination?
Absolutely.
No further questions, Your Honor.
All right, thank you. Does the prosecution have any further witnesses?
The prosecution rests.
Thank you. The defense may call their first witness.
Your Honor, the defense calls Taylor Perkins to the stand. And if I may request one more moment to reposition my camera.
You may.
And Your Honor, before I begin, can you see and hear me all right?
I can, thank you.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Taylor Perkins, and I am best friends with Avery Becker.
And how do you know Miss Becker?
I was on the mock trial team with Avery.
And how was your experience on the mock trial team overall?
The experience was good at some points, but it wasn't the best, especially if Coach Brackman didn't like you didn't always have a great time.
And how do you think Miss Becker did on her performance throughout mock trial?
Avery always did incredible. Even if she was unprepared, she earned the awards and everything. But despite all of that, Brackman still demoted her to the B team.
Why is that?
A month before the regional tournament, Avery had showed up to practice the most unprepared I've ever seen her, obviously making up things on the fly. And Brackman got really furious with her and demoted her to the B team.
What did you think about the demotion?
Avery was the best in there. Senior or not, she deserved to be on A team. She had 4 years to prove her worth to be on that team. And it just wasn't fair at all.
And did you and Miss Becker still hang out after you quit the team?
Of course, she was still my best friend.
Did anything important happen around the time of Mr. Brackman's murder?
Yes, the day prior, Avery had lost her phone at the Fry Shack.
What happened that day?
Basically that day, Avery had tried to go to practice trying to get back on the team, and Brackman told her no. So she came to my place. We were there till the evening, and then we went to the Fry Shack, and some of the mock trial team had showed up.
And what happened then?
Basically, Avery's departure was brought up, and we got into a huge discussion about it. And after Alex had joined the conversation, Avery had gotten really upset and went to the bathroom to cool down.
And you mentioned Miss Fuentes. Did you two ever communicate in or out of mock trial?
Me and Alex wouldn't communicate unless it was absolutely necessary.
And would you say that you know Miss Fuentes?
I wouldn't say we were close, but yes, I do know her.
And is it at all possible while Miss Fuentes was playing with Miss Becker's phone that evening that it could have been stolen?
I can't say if Alex was playing with the phone, but I know that Avery had left it on the table, which showed how angry she was. So that was the last point I saw the phone. I can't say whether or not Alex had took the phone.
Sorry, does the prosecution have an objection?
No, sorry.
Okay, that's okay. I'm sorry. Continue.
And what had happened the next day?
The next day, Avery had come to my house and to pick me up. We had a carpooling plan, so I was trying to text her to see if she was picking me up that day, but I had gotten no response. So when she showed up, I said, "Hey, why didn't you reply?" And that's when we realized her phone had gone missing and we didn't know where it was. That's when we went out to search for it.
And did you skip school that day to look for the phone?
Yes, we did. It's not like we had anything important tests that day, and the other classes were boring, so it was completely fine.
And where did you search?
We had gone to the mall, like where we were the other day, and we had been to the stores we were at. I was calling and texting her phone to hear a notification or a ringtone or something, just to hear sounds so we knew her phone was nearby. Sadly, we never did.
And to this day, have you ever found the phone?
Sadly not, no.
And do you know a Blair Rollins?
Yes, why? She was a girl from my high school.
Well, is there anything that was important about Blair?
She really just...
What's the objection?
The question calls for an improper lay opinion under 701.
Any response from the defense?
Your Honor, I'm simply asking Ms. Perkins if she knew of Ms. Rollins and if there was any identifying thing about them.
And any further response from the prosecution?
No, Your Honor, I stand by.
All right. The question did not require an opinion, and so therefore I am overruling the objection.
Yes, Your Honor. Ms. Perkins, did you get to respond to that?
No, I did not.
So was there any identifying factor about Ms. Rollins?
There's some pretty common knowledge that Brackman was Blair's dad's lawyer in a murder case, and that had gotten Blair's dad sent to jail.
And how do you know this?
Everyone in the school heard about it. It was something that was pretty common knowledge because Blair kept expressing how much he disliked Brackman after that
There's
case.
an objection? Go ahead.
Hearsay and speculation.
All right, response from the defense.
May I ask that my opposing counsel pick out which statement is hearsay?
Certainly. And so which statement are you referring to?
I'm referring to the fact that she's saying that the whole school was talking about it.
All right. A response from the defense.
My response to the hearsay objection. Pursuant to Rule 801, this is not going to show the truth of the matter asserted, which is that everyone was talking about Ms. Rollins only to show that Ms. Rollins was known around the school and that they weren't just a nobody.
Anything further from the prosecution?
Yes, I would also like to add relevance.
Anything further about the hearsay before I allow the defense counsel to respond to the relevance objection?
No, Your Honor.
All right. And anything further that you wish to say about the relevance objection?
No.
Okay. Defense may respond to relevance as an objection.
Your Honor, this is relevant pursuant to Rule 401 as my witness is simply laying foundation as to who could have been an alternate suspect or who had any other ulterior motives.
Can I respond, please?
You may.
The witness is not at liberty to provide any alternate suspects as she's not been qualified as any sort of expert in that area.
So I think that answer went more towards why it was relevant, not that she's identifying an alternative suspect. I do find that it's relevant inquiry as it would relate to an alternate suspect. However, I also find that the statements that are being made by the witness are hearsay. They are out of court statements that are, I believe, going towards the truth of the matter, that this person would have a motive, and that those statements would be, if true, would provide that motive. And so therefore the objection is sustained on the hearsay grounds. May I ask your next question?
Yes, Your Honor. Now, Ms. Perkins, while spending all the day with Ms. Becker, to the best of your knowledge, did Avery Becker kill Mackenzie Brackman on March 6th?
She couldn't have. Avery and I were together the entire day looking for a phone. It's like she had the time to slip away and kill someone.
Thank you, Your Honor. No further questions.
All right, cross-examination.
Yes, Your Honor. You say that Avery and Alex were not friends, correct?
Yes, I wouldn't go. Well, they were okay on the surface, but I wouldn't go out of my way and call them best friends.
All right. And Avery came to mock trial practice unprepared, correct?
Some days, yes.
Made things up on the go and exaggerated.
Well, yes, but it was always relevant to the case more than likely.
And even with making things up on the go and going off script, Avery still won many awards, correct?
Of course, she was the best we had on the team.
And she was definitely recognizable for her talent?
Yes, very.
So it's fair to say that Avery was good at improvising and making things up on the fly, correct?
When it came to cases, yes, she was very good at it.
Moving on, you were a senior and mock trial was something you had done for years, correct?
Yes, 4 years to be exact.
But you did not mind giving up your spot for Avery, correct?
Of course not. Avery loved mock trial, and it meant more to her than it ever did to me.
And you also did not mind ditching school on March 6th for Avery to help find her phone, correct?
Yes, that is correct.
And would you say that Avery is your best friend?
Yes, I would say so.
And you wouldn't want anything to happen to them, correct?
Of course not. I would never want anything horrible to happen to her.
You also say that Avery never left their phone and was basically attached to it, correct?
Yes, unless she was really frustrated at something. That was the only scenario she wouldn't be attached to the hip to her phone.
And you said that it almost acted as a third kidney, correct?
Yes, I did say that.
And Avery left it and didn't remember that they left it until the day of March 6th, correct?
Yes, that is correct, because Alex had upset Avery and she needed to cool down in the bathroom.
And March 6th was the day that Mr. Brackman was murdered, correct?
Yes, that is correct.
And it also took you a while to figure out that Avery's phone was missing, correct?
Yes, that is correct.
So you ditched school to look for the phone and were gone the whole day, correct?
Yes, that is correct.
The day that Mr. Brackman was murdered?
Yes.
No further questions, Your Honor.
Any redirect?
Your Honor, can I first request a brief time check for the defense?
Yes.
The defense has 20 minutes and 9 seconds remaining.
Briefly, Your Honor.
Go ahead.
Ms. Perkins, you stated on cross that Avery was attached by the hip to her phone. And excuse me, she was heated that day, so do you think that there's any possibility that she may have forgot it?
Yes, she was upset. She was just trying to calm down. That was all it was really.
And all the awards that she got and did that, excuse me. Were the awards that she had deserved, would you say?
Yes, she was the best we had on the team, like I've stated previously many times.
No further questions, Your Honor. Thank you.
Thank you. The defense may call its next witness.
Your Honor, at this time, the defense calls Blake Van Owen to the stand.
All right. Please state your name, including your scoring name for the record.
Good afternoon. My name is Paige Flenchy, and I am Blake Van Owen.
May I proceed?
You may.
Ms. Van Owen, what is your current occupation?
I'm a private investigator and I was hired by the Defense Council.
And besides being a private investigator, what other experience do you have with the police and investigation and such things?
Well, I worked as a police officer for some time, and after that, I went back to college to get a master's degree in criminal justice. I also teach police practices and social justice at CU Denver.
Yeah,
Objection, that was a narrative.
response from the defense.
Your Honor, Ms. Van Owen is simply giving her experience as to police practices and procedure and social justice, which is necessary to pass her as an expert witness later on.
Any further response from the prosecution?
I'm not objecting to the specific line of questioning. I'm simply objecting to the manner in which it is being asked, as I feel it is an improper narrative.
Right, thank you. I am overruling the objection. I find that in order to lay the foundation as well as to provide credentials, it is appropriate to answer in a narrative format, and so the answer is proper. You may continue with your questioning.
Ms. Van Owen, what professional experience do you have with police practices and procedure?
I've testified to police practices and procedure in over 100 cases, along with forensic data analysis, cell tower data analysis, and many other expertises.
Your Honor, at this time, the defense would like to admit Ms. Van Owen as an expert in general police practices, including forensic evidence techniques, crime scene reconstruction, and cell tower analysis.
Hang on, let me get general police practices, forensic evidence techniques, and then what else?
Crime scene reconstruction.
Okay,
And cell tower analysis.
thank you. Any objection from the prosecution?
Yes, Your Honor, I do not feel that any foundation has been laid as to her experience, training, or education in crime scene reconstruction or cell tower analysis.
Response from the defense.
Ms. Van Owen has stated much experience as a private investigator and as a professor of police practices and procedure, and that encompasses forensic evidence techniques as well as crime scene reconstruction.
And how about the cell tower analysis?
Her experience as a private investigator and as she is testified as an expert in those fields encompasses cell tower analysis as well.
Any further response from the prosecution?
I did not hear any testimony as to her experience in those fields, so I stand by my objection.
All right. In terms of the cell tower analysis, I do think some additional foundation needs to be laid. I do agree that the background on the other areas in terms of general police practice, forensic evidence techniques, and crime scene reconstruction, I think those have been properly laid, but the cell tower analysis needs additional foundation. I will admit her as an expert in those fields, and if you wish to lay further foundation as to cell towers, you can do that and then re-ask to admit.
Yes, Your Honor. Ms. Van Owen, can you tell us how your experience as a private investigator and professor and police officer has given you experience in cell tower analysis?
Of course. As a professor, I teach police practices, which encompasses the use of cell phones and their data in investigations. Additionally, as a private investigator, I have to go through all police reports and all of the evidence in each case that I work to form my conclusions.
Now at this time, Your Honor, I move to admit Ms. Van Owen as an expert in general police practices, including forensic evidence techniques, crime scene reconstruction, and cell tower analysis.
Any objection from the prosecution?
No, Your Honor.
She is so qualified.
Yes, Your Honor. Ms. Van Owen, can you please briefly tell us what the prosecution has claimed happened today?
Well, the prosecution claims that Avery Becker broke into Mackenzie Brackman's house, engaged in a brief struggle, and then fled after accidentally killing the victim.
Do you believe that this is what occurred?
No.
Why not?
Well, there are 6 main points that make it infeasible. We have number 1, the knife block, number 2, the scuff marks on the floor, Number 3, how the knife was held. Number 4, the text messages. Number 5, the cell tower analysis. And number 6, the lack of other suspects.
Let's go into your first reason why the prosecution's case was rushed, this knife block and this knife drawer. Your Honor, at this time, I ask to display exhibits 5, 7, and 8, which I believe have already been admitted into evidence.
They have, and so you may display them.
Ms. Van Owen, can you first describe what these exhibits are?
Of course. Exhibit 5 shows the bloody murder weapon, and Exhibit 8 is a knife block that Kyle Kuzak claims that that knife may have come from.
And can you explain your conclusions from the details in these images?
Of course. In Exhibit 5, you can clearly see that the knife is solid metal. And if you scroll to Exhibit 8, the knives in this set are half wood, half metal, which means that the murder weapon did not come from this set.
Thank you, Ms. Van Owen. Let's move on to your second problem with the prosecution's case, the scuff marks. Can you explain these?
Of course. Ms. Kuzak claims that the scuff marks found in the victim's house indicate that a struggle took place. However, because we cannot date these scuff marks, we don't know how or when they were made, which means they are unreliable evidence.
Thank you. Now let's move on to your third problem with the prosecution's case. Your Honor, at this time, I move to display exhibits 3, 4, 19, and 21, of which 4 and 21 have not been admitted, so I wish to display those for the purposes of identification.
We may display those exhibits.
Ms. Van Owen, do you recognize exhibits 4 and 21?
Yes, I do. Exhibit 4 is a close-up of the wound given to Mackenzie Brackman, and Exhibit 21 is a photo of my hand holding a knife.
And are these fair and accurate to the best of your knowledge?
Yes, they are.
Objection, Your Honor. Lack of foundation. We have and relevance. We have no idea why this image is relevant to the case, and I do not believe that enough foundation has been laid to, or actually just relevance. I do not believe that that we have seen why this is relevant to the case.
And I'm going to allow, I don't know if are you intending to offer it right now, or are you asking additional questions before you ask to admit it?
I was planning on asking questions as to the relevance of these images after admitting, but I can lay foundation now if you want.
Well, and so I guess in terms of the objection, I'm going to overrule it currently because the exhibit has not yet been asked to be entered into evidence. And so long as additional foundation is laid, I'll allow the questioning to continue, and then you may make your objection if that becomes appropriate.
Thank you, Your Honor.
Thank you.
Your Honor, do you want me to lay foundation prior to admission?
Yes.
Ms. Van Owen, can you explain why this image of you holding the knife is important to your interpretation of this case?
Of course. In my opinion of the case, the way that the knife was held, in Kuzak's opinion, is wrong. So this is a possible hold of the knife in order to deliver the wound given to Mackenzie Brackman.
Your Honor, at this time, I move to admit exhibits 4 and 21 into evidence.
Any objection from the prosecution?
I would like to again object to exhibit 21, as this knife is clearly a different brand, size, and shape of the knife used in the murder, and I still have not seen why it is relevant, as it is a visibly dissimilar knife.
Response from the defense.
Your Honor, this knife is not meant to be visibly similar to the knife that was the murder weapon. However, as they share the same basic components, a handle and a blade that gets thinner towards the end, it can still be used as a demonstration for the knife that was the murder weapon.
Any further response from the prosecution?
I stand by my objection.
All right. Exhibit I'm sorry, from the prosecution, is there any objection to Exhibit 4?
There is not.
All right. Exhibit 4 is admitted. As to Exhibit 21, I find that a foundation has been laid for this particular photograph. I do find that there's relevance to it as described by the witness. I also find that while the knife is not identical, it's close enough from the other photographs of the knives to be similar, and the fact that the handle may be different is not part of that determination. I do find that that would go towards the weight that would be given to it, not its admissibility. Therefore, Exhibit 21 is admitted. Both exhibits published to the jury. You can continue with your questions.
Yes, Your Honor. Ms. Van Owen, let's start with Exhibit 4. Mr. Hernandez, can you please? Thank you. Ms. Van Owen, can you please explain what's going on in this exhibit?
Of course. In Exhibit 4, you can see the wound given to Mr. Brackman lies laterally across his chest. This wound would be very, very hard to deliver in an over-the-shoulder bear hug, like Cusack claims. Additionally, it would require the attacker to be much larger than the victim.
Can you explain further how you've determined the different sizes of the victim and the attacker based on the knife wound itself?
Well, according to Exhibit 19, the victim's cause of death was blood loss, and the knife wound punctures through his scapula, which is his shoulder blade, and into the top of his heart. This requires an immense amount of force, especially to deliver such a wound to a grown man. That means that the attacker must have been significantly larger than the victim.
And can you just briefly state again the differences between your conclusions here and Ms. Cusack's conclusions with the same knife wound?
Objection asked and answered.
Any response from the defense?
I'm asking a more specific question, Your Honor, than I had been before, and there should be a different answer because it is a slightly different question.
All right, and anything further from the prosecution?
I feel that the witness has already answered what she believes to be the difference between her interpretation of the case and Ms. Cusack's interpretation of the case. So I don't feel like it is necessary for her to restate that.
I do find that the question used the word again, so it does indicate that the answer is the same. If you wish to re-ask the question in a different way, perhaps, but the question itself, I do find wasn't different enough, and so I'm sustaining the objection.
Yes, Your Honor. May I re-ask the question?
You may.
Ms. Van Owen, can you please describe how Cusack's interpretation of this is inaccurate according to your theories?
Of course. Ms. Cusack claims that this wound would have been delivered in an over-the-shoulder motion like a bear hug. Unfortunately, the amount of force that this type of wound requires rules that out. In order to puncture through the scapula and into the top of the heart, the attacker would have to be 1, significantly larger, or 2, have surprised Mr. Brackman from behind.
And now let's talk about Exhibit 21. Mr. Hernandez, thank you. Can you please explain how this knife hold ties into your previous explanation of the knife wound?
Of course. This type of hold would give the attacker significant force to puncture through the shoulder blade and into the top of the heart, and as well would be a more stable hold and give the type of lateral wound as you saw in Exhibit 4.
Thank you, Ms. Van Owen. Let's move on to your fourth problem with the prosecution's case, these text messages. Can you explain these?
Of course. The text messages accepted by Detective Markowitz are very unreliable, seeing that they are screenshots. The police have a technology called Celebrite, which can be used to download the contents of phones, and the lack of using that means that this evidence is unreliable.
Can you explain further as to how this evidence is unreliable and any evidence as to that specifically?
Of course. Seeing as they're screenshots, they can be easily doctored by a photoshopping app or even sent from a stolen phone. And because the police decided not to use their Celebrite technology, we don't have a verifiable copy of these.
Thank you, Ms. Van Owen. Let's move on to your fifth problem, the cell tower data. Your Honor, at this time, I would like my trial technician to display Exhibit 16, which has previously been admitted into evidence.
You may do so.
Ms. Van Owen, can you please describe what this diagram of these cell towers is telling you?
Of course. This diagram shows the area that 3 cell towers Avery Becker's phone connected to cover. They don't pinpoint the location of the phone or where the person itself, their self was.
Can you explain how a cell phone connects to cell towers like these?
Of course. Cell phones connect to the tower with the best reception, which means they can connect to towers even 7 to 8 miles away. In this case, we don't know where the phone was when it connected to these, so we don't know when it happened either.
So even if the phone connected to the cell tower nearest to Brackman's residence, does this mean that the phone was in fact in Brackman's residence?
No, it could be almost anywhere in that area.
Thank you, Mr. Hernandez. You could take the exhibit down. And let's move on to your 6th and final problem, the lack of other suspects. Were you able to find any?
I found it concerning that the police did not fully investigate Blair Rollins.
Please explain Blair Rollins further.
Well, Blair Rollins has a much stronger motive to commit this sort of crime, seeing as their dad was sent to jail for murder by Mackenzie Brackman. Additionally, they are around the same height and build as the intruder in the ring videos.
Do you know where Blair Rollins is now?
No, Blair Rollins vanished after their graduation from Colorado High School.
And was Blair Rollins at school on the day of the murder?
No, they were not.
Thank you, Ms. Van Owen. No further questions at this time.
Cross-examination.
Yes, Your Honor. So, Mrs. Van Owen, you said that you taught, you said today that you taught about cell tower analysis in your class, correct?
It's Professor Van Owen, thank you very much. And yes, I do.
Please tell me where exactly in your witness statement it says that.
I don't use the exact wording, but in police procedures, it's a common practice.
But according to your witness statement, you do not, it does not say that you teach about cell tower analysis in your classes, correct?
I do not use the exact wording. I teach cellular data analysis in my classes, but that would take forever if I wrote out every single thing that I did in my class.
Well, wouldn't it be pertinent to, you were able to make a witness statement in this case, correct?
I was.
And you were able to update it with at any point if any new or relevant information occurred to you?
Yes.
How could you think that a central theme of this case, that being cell tower analysis, would not be relevant?
I'm not sure how you think that it's not relevant in my statement. I state that I teach police practices, and police practices include cell tower data analysis.
All right, moving on. Might it be possible that if you had seen the blood spatter, you would have come to a different conclusion?
It's possible, but seeing as I couldn't see it, there was a hindrance.
And is it possible that the perpetrator could have left with the knife that was found, that was missing in the block?
Why would they?
Sorry, ma'am, you cut out.
I'm confused as to why they would take a knife and nothing else from the house, but I suppose it is possible.
And is it possible that if perhaps that knife had been broken, Mr. Brackman would have could have replaced it with the knife that was found at the scene?
I guess, but I highly doubt it. Most people like to keep their knife sets very organized.
And is it possible that if you had if you were holding a different knife, you would grip the knife differently?
I guess, yes.
And so your holding of the knife in Exhibit 21 could be different from how one would hold the knife that was used in the murder, correct?
It's a possible hold. We don't actually know.
Thank you, Your Honor. No further questions.
Thank you. Any redirect?
Yes, Your Honor. Ms. Van Owen, do you think it's necessary to list all of the subjects that you would teach in your class?
No, the subtitle of police procedure covers everything that I teach.
And do you think that it is more important to look at evidence that points to things that may be possible or things that may be likely?
Things that may be likely.
Thank you, Ms.
Objection,
Van
Your
Owen.
Honor, outside the scope of the cross-examination and also leading.
Response?
You may.
This is not a leading question because I was giving Ms. Van Owen multiple different answers to give. This was not a yes or no question, and she could have explained her answer further if she wished, and I do not understand why this is outside of the scope of the cross-examination.
Anything further from the prosecution?
It is outside the scope of the cross-examination because, sorry, never mind. I withdraw my objection.
All right. Since the objection's overruled or withdrawn, I will not rule on it. And so I think the answer stands. I believe you've concluded your your direct examination. Is that correct?
Yes, that is correct, Your Honor.
Thank you. This witness is concluded. Then we would have the defense call their next witness.
The defense calls Avery Becker to the stand. Give me one moment to adjust my camera.
Certainly.
Good afternoon. Could you please introduce yourself to the jury?
Hello, my name is Avery Becker.
Why are you here today, Ms. Becker?
I'm here today because I'm being accused of murdering my mock trial coach.
Now, this may seem like a silly question, but did you commit this crime?
No, I would never kill Brackman, my mock trial coach. I feel awful for the fact that I won't be able to apologize to him, but I would never kill him.
We'll come back to that in a moment. Could you tell the jury about your experience in the mock trial program?
Yes, throughout my time competing for mock trial, I realized that it came pretty easy to me and that I didn't have to try as hard as other students did.
Did Mr. Brackman like this style?
No, Brackman made it abundantly clear that he thought that my work ethic was lazy. He did not understand how I could go into practice and know exactly what I was going to ask. And he hated when I diverted from a script.
How would you describe your relationship with Mr. Brackman?
Brackman and I's relationship was tense to say the least.
Now, let's talk a little bit about the car incident that Ms. Cifuentes mentioned earlier. Could you tell us a little bit about that?
Yes. One day after regionals, we were going over what we did well at practice. I thought that maybe Brackman would congratulate me on my Best Attorney Award. However, he didn't. He said that I didn't deserve the award and got on my case about not sticking to my closing.
How did this conversation make you feel?
This conversation I was crushed. I got so mad that I stormed out in the middle of practice. And when I got outside, I saw his prized possession, his Porsche. So with what I thought was a dry erase marker, I wrote Worst Attorney Award on it.
What happened immediately after?
Brackman came outside and blew up at me. He was so mad and he kicked me off the team.
How did vandalizing Mr. Brackman's car make you feel?
I wasn't thinking about it in the heat of the moment, and I feel awful about it. It was one of the worst things I've ever done.
Now, did you ever make an attempt to get back on the team?
Yes, of course I did. The next day, I went down to Brackman's office, but according to his secretary, he was not willing to talk to me and too busy. So because of this, I unfortunately had to text him instead of apologizing to him like I wanted to in person.
Now, moving along, where was your phone on March 6th?
March 6th? I honestly don't remember. I misplaced it.
Where were you on March 6th?
On March 6th, Taylor and I went to the mall and the Fry Shack to look for my phone. We decided to skip school and to go look for it. We looked all over the Fry Shack, the mall, pretty much anywhere we were. We used Taylor's phone to call my phone, and we still couldn't find it because it kept going to voicemail. So we either figured that it was either lost or stolen.
Your Honor, may my trial technician display Exhibit 14 for the witness?
Yes.
Ms. Becker, are these your texts?
No, I never sent any of this. I don't know who's framing me, but I never sent any of these text messages, and these aren't mine.
Now, were you at Mr. Brackman's home on March 6th?
No, I don't know where Brackman lives.
Objection, Your Honor.
Yes.
Relating to the question before the one just asked, it calls for speculation, assuming she's being framed.
Response from the defense.
Your Honor, the witness was just testifying to a possible reality of why these text messages exist, as she has just testified to not being in possession of these. She didn't mention who could be framing her, therefore this is not speculation as pursuant to Rule 701.
Response from the prosecution.
I stand by my objection.
I am going to overrule the objection. I don't find that it's an improper speculation, and therefore I'm going to allow the answer to stand. So you may continue with your questioning.
Yes, Your Honor. Were you at Mr. Brackman's home on March 6th?
No, I don't know where Brackman lives. I couldn't be there if I didn't know where he lives.
And finally, did you kill Mr. Brackman on March 6th?
No, I didn't kill Brackman. I would never kill anyone. No, Brackman and I did not have the best of relationships, and I'm not going to say that we did, but I didn't kill him. I'm not a killer.
Thank you, Your Honor. No further questions.
All right. Cross-examination.
Yes, Your Honor. Okay. You and Mr. Brackman had numerous conflicts in the mock trial, didn't you?
Yes, unfortunately we did.
And you believed that Mr. Brackman never gave you credit for anything you did.
No, Brackman was constantly on my case about my work ethic.
And he even bumped you off of the A team to the B team, didn't he?
Yes, unfortunately.
And he did this because you were not prepared, didn't he?
No, he did this because he hated my work ethic.
Does that relate to you not being prepared?
I was prepared. I knew what I was going to ask. He did not like the way I worked, though.
Well, you did manage to get back on the A team, correct?
Yes, I did.
But your friend Taylor had to give up their place just so you could stay on the A team, didn't they?
Yes, Taylor did that, and I'm very thankful that she did. I didn't ask her to do that, though.
Seeing as you resigned, would you say that Taylor would do a lot for you?
Well, Taylor and I were friends, so as friends, you do things for each other.
So Taylor was willing to sacrifice herself for your benefit, correct?
I don't understand what you're asking.
Would Taylor be willing to do a lot for you?
As I said, friends are willing to do a lot for others. So yes, Taylor did do things for me.
Okay, and even after
commenting.
Response from the prosecution.
May I move on from the question, Your Honor?
And so I guess I didn't understand what you were referring to in the defense's objection in terms of comment. Can you elaborate?
Your Honor, after my witness answered, Mr. Andrew responded with okay, and then proceeded on his question. Okay would be commenting on the evidence, which is not allowed under the rules of procedure.
And do you have a response to that, Mr. Andrew?
I was just saying okay for a transition and to acknowledge that I knew what the witness was answering to my question.
Any further response from the defense?
Again, it was still commenting on the evidence. There are other transitions that he could have used.
I'm overruling the objection. I did not, I heard it the same way that Mr. Andrew explained it. And so therefore I don't find it was an improper comment on the evidence. So the objection's overruled.
Yes, Your Honor.
Andrew.
And even after your success and awards, he didn't congratulate you, did he?
Who? Brackman?
Mr. Brackman, yes.
No, Brackman never congratulated me on my award and was on my case about it.
And you then proceeded to vandalize his car, correct?
Yes, it was a big mistake of mine, though.
And then he kicked you off your team and insulted your friend Taylor, correct?
Yes, he did kick me off the team.
And this only amplified your anger, correct?
I was angry
Objection, improper character evidence to a specific instance of conduct as pursuant to Rule 404.
Which, can you be more specific as to what incident you're referring to?
Your Honor, the prosecution is going to show that because Ms. Becker reacted in an angry, rash way this time, that she also did this on the day that Mr. Brackman was murdered. They are using this to show act in accordance, which is not permissible under Rule 404.
Response from the prosecution.
This is in her witness statement.
Any further response from the defense?
They are still using it as a character, as a specific instance of conduct used to show act in accordance. So it is still against the rules of evidence as pursuant to Rule 404.
May I respond?
You may.
I'm using it to establish a pattern of rash behavior under extreme emotional duress. And under the same Rule 404, it shows identity and motive.
Further response from the defense?
One moment while I pull up the rule, Your Honor.
That's fine.
Your Honor, this does not fall under the exception to 404B, 404B2, as they are not using it to show that it proved motive, as it's not going to a motive. They are simply using this to show a wrong or other act to show that the defendant acted in accordance with this specific instance of conduct. Therefore, it's not permissible under Rule 404B.
So I will note that the defense brought up the incident in the direct examination, and so therefore the incident itself is already into evidence. I also find that in terms of motive, it would be relevant and permitted use of this type of evidence if that's the purpose for which it's been introduced. Therefore, I'm overruling the objection.
Yes, Your Honor.
Thank you, Your Honor. And this only amplified your anger, correct? With Mr. Brackman, of course.
I was angry at the time once I got kicked off the mock trial team, but once I realized what I did, I realized that it was a big mistake. I felt guilty of that, of writing on Brackman's car.
But at the time, you were quite angry with Brackman, yes or no?
At the time, yes.
And you also said that if you would get back at Mr. Brackman if it was the last thing you did. Yes or no?
No, I never said that.
And you are saying today that you never said that you would get back at Mr. Brackman if it was the last thing you did here today.
No, I never said any of those words.
And you know that you could have updated your witness statement at any time up to this trial.
Yes, I do.
Your Honor, may I please show the witness statement of the witness here today after I pull it up?
Yes.
Could you please read for me lines 104 and 100?
Objection, improper impeachment. May I be heard?
You may.
Your Honor, my witness has not been given the opportunity to confirm nor deny that this is her witness statement, nor has she been given the opportunity to see her signature of this witness statement.
Response from the prosecution.
I can proceed to lay down that foundation if needed.
Yes, please do so.
Avery, is this your witness statement?
I do not see the name on the witness on the affidavit. That is my signature, yes.
And is this your affidavit?
Yes, it is.
Will you please read lines 104 to 105?
Yes, one moment, please. I told her I would get back at him if it was the last thing I did.
Thank you. Next, you claim that you do not know where Mr. Brackman's residence is, correct?
I don't know where Brackman's residence is.
But you could identify Mr. Brackman's car correctly.
Yes, I did know what Brackman's car looked like, but I didn't know where he lived.
Okay, so if you were to look up the license plate, would it show you the address of the residence? Yes or no?
I don't understand.
Objection, outside the scope of this witness. She's not been qualified as an expert in any sort of investigation or police procedure. Therefore, she would have no knowledge as to how one would go about looking up a license plate number.
Response from the prosecution.
May I please confer with my counsel?
Yes.
Your Honor, I am ready to respond.
Go ahead.
It does not fall under an exception or expert opinion, and it can be inferred that you can find the address.
Your Honor, may I respond?
You may.
Ms. Becker is a college student and has no previous background in any sort of investigative procedure or any sort of police procedure. Therefore, she has no knowledge of how of whether or not one could look up a license plate number to find personal information. And even if she did know that, she would have no idea how to look that up and where the appropriate place to look up a license plate number would be.
I am overruling the objection because I find that the question itself did not ask for an expert opinion. If she doesn't have that within her information, that is the answer that she can give. But the question itself was not requesting an expert opinion. So therefore, the objection is overruled. You may answer, Ms. Becker.
Can you please re-ask the question?
If you were to look up his license plate, would it show you the address of his residence?
Honestly, I don't know how I would do that, so I don't know.
Talking of not knowing, you vandalized Mr. Brackman's car with permanent markers, didn't you?
I thought it was a dry erase marker at the time. I didn't know it was a permanent marker.
Could you please answer my question, Ms. Becker?
Yes, I did vandalize his car, but it was a mistake and I didn't know it was a permanent marker.
But you had used these pens before, correct?
Markers, yes.
Okay, moving on. You liked your phone, didn't you?
Yes, as most human beings do.
And you claimed you lost your phone the day before the murder incident, correct?
Yeah, I misplaced it. I don't know where it went.
And only your best friend Taylor can testify to that.
Yes, she must have noticed that I was missing it too.
And you skipped a whole day of school just to look for your phone on the day of the murder.
Yes, there was nothing that important at school, so it was justifiable.
And this day you were gone and absent was the same day of the murder. That was the same day of the murder. The only person who can testify to where you were.
Objection asked and answered. My witness has answered this question, this exact question, several times.
He's not finished with the question. I'd like to hear the whole question before, and if you wish to make the objection at that point, but it was the middle of the question. So go ahead and ask the whole question.
Thank you, Your Honor. And this day that you were gone, the same day of the murder, the only person who can testify to where you were is your best friend, Taylor.
Objection asked and answered. Ms. Becker has already testified that Ms. Perkins was with her and is testifying to her whereabouts of that day, and that the day she skipped school was the day of the murder. She has already answered all parts of this question before.
All right, Mr. Ian, go ahead and respond.
When I questioned about her best friend Taylor testifying to hers, I was testifying to whether or not she had lost the phone, not to where she was.
Any further response from the defense?
Your Honor, Ms. Becker still answered the question that Ms. Becker would be testifying to her whereabouts and that Ms. Becker was with her. So this question has already been answered.
I'm sustaining the objection. I do find that it's been asked and answered.
I request that I move to strike the question from the record.
All right, the question is stricken.
Yes, Your Honor.
Also, you mentioned you were quite good at mock trial, correct?
Yes, I was.
You also said that you were good at luring judges, correct?
I was good at making them believe my side of the case.
Could you please answer my question?
Yes, I was good at making them believe what I believed on that side of the case.
And there is a judge here today, correct?
Yes, there is.
And one more question. You refused to talk to law enforcement, didn't you?
I was told not to.
Can you please answer my question with a yes or no?
Yes, I did.
No further questions, Your Honor.
All right. Redirect.
Before I begin, I would like to inquire as to how much time I have remaining.
The defense has 3 minutes and 49 seconds remaining.
Yes, Your Honor, I would like to redirect.
Go ahead.
Ms. Becker, on cross, you were asked about the statement you made to your mother that you would get back at Mr. Brackman. Could you elaborate on some of the context behind that statement?
I was very angry at the time, and I just couldn't believe that I was kicked off the mock trial team. And so out of anger, I said that, but I never would actually.
Would you ever act upon that statement in any fashion?
No, I wouldn't.
You were then asked on cross about your cooperation with law enforcement. Is there any reason you chose not to cooperate?
I was told not to
By who?
by my attorneys.
Finally, where were you on March 6th?
On March 6th, I was at the mall in the Fry Shack looking for my phone with Taylor Perkins.
Is Taylor Perkins the only person that could attest to your whereabouts that day?
Well, I'm sure other people saw me because we were in a public place.
Thank you, Your Honor. No further questions.
All right, thank you. Does the defense have any further evidence?
No, Your Honor, the defense. No.
Go ahead. I didn't mean to cut you off. I saw there was an objection. Go ahead.
I removed my objection.
Oh, okay. I'm sorry. I cut you off, sir. Please continue with what you were. Does the defense have any other evidence?
No, Your Honor, the defense rests.
Thank you. All right. Is the prosecution ready to make a closing argument?
Yes, Your Honor. We would request that the remainder of the time be used for rebuttal.
And that will be reserved.
Thank you. Ladies and gentlemen of the jury, members of the court, today I'm here to ask you to convict a murderer who, might I add, just lied under oath. Today, there are two most majorly important jury instructions. First, instruction number 3. A fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. We have provided a case that is strong with circumstantial evidence. We have shown strong inferences that it is likely that Avery Becker committed this murder. In addition, I would like to direct your instruction to jury number I would like to direct your attention to jury instruction number 7, which states the elements of the crime of murder in the first degree, which is what Avery Becker is being charged with today. And those are that the defendant, Avery Becker, in the state of Colorado, at or about the date and place charged, the home of Mackenzie Brackman on March 6, 2020, acting alone or with one or more persons, committed or attempted to commit second-degree burglary, and in the course or in furtherance of the crime of second-degree burglary that the defendant was committing or attempting to commit, or in the immediate flight therefrom, the death of a person other than one of the participants in second-degree burglary was caused by anyone. And after considering all of the evidence, you should find the defendant guilty beyond a reasonable doubt of murder in the first degree. Today, we saw a story of burglary turned to butchery. We heard from Detective Jordan Markowitz, who placed Avery Becker at the scene. We heard from a good friend of Avery's, Alex Cifuentes, who told us about Avery's plan to vandalize Mr. Brackman's house. We heard from Kyle Kuzak, who told us about how the murder went down. The defense tried to rebut this with two best friends, again, one of whom who lied under oath, with everything to lose if Avery was convicted, and an expert who was educated in an online school. Today, you heard the story of a disgruntled student who attempted to break in and vandalize the home of Mackenzie Brackman, just like she did to his car. Today, we showed you the story of a burglary turned to butchery, where the phone of Avery Becker, his third kidney, showed up at the scene, where the victim was found dead, where there was a struggle and Mackenzie Brackman was killed. We saw text messages from Avery Becker expressing his plan to trash Brackman's house. Ladies and gentlemen of the jury, we ask that you follow the facts today and find Avery Becker guilty of murder in the first degree.
Thank you. Closing argument for the defense.
Yes, Your Honor. If you give me just one moment to fix my camera.
All right, and we're gonna wait 1 second. We have an audio that went out for one of the scoring judges, and so she's gonna need to log out and then back in. So if we could all just be patient for a moment, we can let her do that. All right, I believe we got her back. Can you hear okay, Ms. Jones?
I can. I am so sorry about that.
No worries. I'm
from
glad
the I unplugged it from the charger and it just decided to stop. So thank you. So much.
All right, whenever you're ready with your closing.
Your Honor, before I proceed, I ask if you can hear and see me all right.
I can, thank you.
If at any time that changes, feel free to stop me so I may correct the technical issue.
Very good.
May it please the court.
Yes.
There is no evidence. The prosecution put a young girl on trial for murder without bringing a single piece of evidence tying her to this crime. The prosecution wants you, the jury, to find Miss Avery Becker guilty without meeting their burden. Let's talk about what the prosecution's burden was. They had to prove beyond a reasonable doubt that Miss Becker was guilty of 2 counts: burglary of a dwelling in the 2nd degree and 1st-degree murder. Let's break down what these mean. 2nd-degree burglary of a dwelling is defined that Miss Becker, on or about March 6th, unlawfully entered and remained in Miss Becker's home, in Mr. Brackman's home. The 2nd count, murder in the 1st degree, states that while Miss Becker was in Mr. Brackman's home, Mr. Brackman died. They had to prove both of these counts beyond a reasonable doubt. What is a reasonable doubt? Reasonable doubt is defined as a person that would hesitate in matters of importance to themselves. A mere hesitation is all that is required for you to return the verdict of not guilty. After all that you have heard in today's case, you must have much, much more than just a mere hesitation. Now, let's talk about the evidence, or the lack of evidence. You heard all about Detective Markowitz's failed investigation. You heard them talk about how they knew Miss Becker had an alibi, but they chose not to investigate. You heard them tell you directly there was no DNA, no fingerprints, and no eyewitnesses. So what evidence do they think they have? A video and a cell phone, neither of which can directly be tied to Miss Becker. Let's start with the video. The Ring video that they brought forward as evidence only shows a masked intruder entering Mr. Brackman's home. The cell phone that they claim as evidence only shows that Miss Becker's phone connected to a tower near Mr. Brackman's house. However, you heard Miss Becker tell you she wasn't even in possession of her phone on March 6th. This, however, is not the end of Detective Markowitz's unfinished investigation. You heard Detective Markowitz You heard Detective Markowitz tell you how they simply asked Ms. Cifuentes to send screenshots of her phone instead of using any sort of forensic software to examine it. They even waited a full 3 months after the crime took place to ask them to send in these screenshots. Now, let's talk about Kyle Kuzak and their interpretation of the evidence. They claim that after being alerted by his Ring surveillance system that Mr. Brackman grabbed a kitchen knife, and through the subsequent struggle, the intruder took possession of the knife and stabbed Mr. Brackman. They think that they can gain all of this from undateable scuff marks on the floor and a broken plate. You also heard them fail at answering basic questions about their investigation and continuously responding, "I don't know," when asked direct questions about her investigation. You also heard Professor Van Owen tell you about what the evidence actually shows. You heard Professor Van Owen tell you there is no reliable evidence of a struggle. After all that you have heard today, there is no possible way that you can give the verdict of not guilty, a verdict of guilty. You cannot be sure beyond a reasonable doubt because the prosecution has brought forward no evidence. Because of this, you must give the only just verdict, the verdict of not guilty. Thank you.
Thank you. All right, you may conclude your closing arguments from the prosecution.
May it please the court?
Yes.
There is one thing that the defense just said that I do agree with. You cannot possibly return a verdict of not guilty. In this case, they talk extensively about assumptions and how we make very many assumptions. And then they also talked about how we use circumstantial evidence. May I remind you of jury instruction number 3? Circumstantial evidence is fine. In addition, they talk extensively about Miss Van Owen's investigation, personal investigation. Her investigation was based on incomplete evidence. She did not go and search. She did not do a thorough investigation at all. They talk about assumptions. They make some of the largest assumptions, like how when one of their own witnesses testified that Avery Becker's phone was like a third kidney to her, that her phone was lost and she did not notice until almost 12 hours later. They talk about how the Ring doorbell and the Ring video is not conclusive. It is not there to say that video shows a person of similar height and build to Miss Becker. So it could be Miss Becker. There is a overwhelming amount of evidence that maybe none of it directly says, oh, this was Miss Becker, but the sum total of the evidence should show you that you have to return a verdict of guilty. Thank you, Your Honor.
Thank you. All right, this trial is concluded. I'll have the scorekeepers turn in their their score sheets. And once those are turned in, we can turn on our videos and make any comments that we may have. So if the scorekeepers, once you've done that, can just turn on your video, then I'll know that that's been completed. All right, I'll start quickly. I know that they give us a couple of minutes each to give any comments, and I just want to say what a great job everyone did. I very much appreciate the professionalism and how everyone was patient whenever there were hiccups throughout the day or throughout the afternoon. The only comments that I would have in terms of just things to work on, I think objections are a hard thing, just kind of knowing when to make them, because I don't think you have to object every time there's a possible objection. At the same time, you're being scored, and that's part of what's being scored. That's why I understand that. But sometimes think about whether or not you need to object on all of them. Additionally, just slowing down a little. There was a couple of times where it's, as the judge, there are things I have to keep track of, and I missed it. And so that's why I had to ask some questions. But you all did a great job of keeping your theme going throughout the case, working with witnesses who weren't going the direction you wanted to go. I thought that you handled witnesses very well on the whole, and overall did a really nice job. And so wish you all the best of luck in any future rounds. So I don't know if Ms. Kent, if you want to start. I'm just going across the top of my screen.
Sure. What a fun round to watch. That was really a pleasure to watch. Both teams, I thought, did a really good job. I think head to head, you guys were pretty evenly matched. I was really impressed with your ability to argue objections and to respond to objections, and having the rule numbers and being able to kind of apply what was going on to those rules. So I was really impressed with that, particularly with the attorneys who did witness Cifuentes and witness Perkins. There were some back and forth exchanges there that I thought were really good. So, and I think that's one of the hardest parts of doing a trial is the objections. I also liked how Mr. Newman tied the theme from the opening statement into his closing argument, and kind of reminded me of everything that was said in opening statements. So I thought that was really good too. But good job. That was a pleasure to watch.
Ms. Smith?
All right, thank you. I just want to say thank you, everyone, because it was so fun to watch. I know that these cases are kind of difficult in what you're given and how you're given. And to handle all of that, like on top of a school load too, is not the easiest thing ever. But you guys did an excellent job, and it was very entertaining to watch. I think the strongest parts of the cases were definitely direct and cross-examination. It was very clear that you all prepared very well for that and really took into consideration everything that was going on. I think one of the hardest things to do as an attorney is to make sure that you're actually listening to the witness, and I could see a lot of that going on too. So really excellent work, everyone who was involved. If I could give any critiques, it would be to make good use of your time. Your time is your budget when doing these cases, and to allocate those resources accordingly is a really smart thing to do. Part of that is the quality of exhibits that are admitted, and what you do with those during a cross or a direct examination is really, really important. It was way better to admit one piece of evidence and to actually discuss that and show how it's relevant to a case than it is to admit like 8 different pieces of evidence and not even talk about them. You definitely don't get points for how many you admit, you get points for how you use them. And that really goes to help build a case. So that would be, I think, my only real critique, besides just, make sure on objections that you're making objections that are really helping your case. If it's not helping your case, and if it's not the most important objection to make, where you cannot allow this piece of evidence or this piece of testimony in, don't make the objection. It's just going to kind of throw everything off. You lose your place. And that kind of just comes with time, I think, and experience. But you guys did a really excellent job, and thank you so much.
Ms. Jones?
Thanks. So I am also super impressed with all of you guys. I mean, I did mock trial, but it was when we were allowed to actually be in person, and the difficulties of doing this in this format is insane. So you guys really did awesome. I do agree with what everyone said about objections and thinking carefully about what you're lodging. But I want to put a big caveat on that because it's one of those things in the mock trial world that in mock trial world, you have this time limit, but I'm a criminal defense attorney. And so I loved, like, I think it was Mr. Winton, who was arguing that that video and that person in the video, because you don't know who it is, isn't relevant. Like, it's so relevant. I mean, it's literally a video of the person walking into the crime scene. So like, it's super relevant. But as a defense attorney, like that kind of just like, you fight against any piece of bad evidence that you don't want come in and you put it all out there. And so it's a thing in mock trial that you kind of have to think about with timing. But in like, I, as a criminal defense attorney, loved that you guys were fighting every piece of evidence, even though it was clearly relevant. And TJ, Mr. Newman on the other side, you know, don't be afraid to just be like, Judge, it's clearly relevant. Like it literally is the person that's committed this murder. I know that it doesn't, if it clearly showed that it was whoever, then we wouldn't be having this trial, right? Like, of course it's not that obvious, but you know, don't be afraid to answer like it's clearly relevant, like, come on. But overall, I thought you guys did really good. The biggest thing, I think is also just slow down. I say that as I talk really fast because I'm a fast talker. So it was one of the biggest things that I struggle with even now is not talking super fast. But I find even on Zoom, it's even more important because sometimes those glitches happen. And if you're talking really fast, then there's more than one or two words that your audience is missing. Versus if you're talking slow, maybe that glitch doesn't affect your speech as much. But I thought you guys did really great. And can I just ask, I think all of your cameras are on, who actually like has an interest? I mean, you guys are teens, but like in thinking that they might go into law or some kind of law related career? A couple of you? Good. Just interested. That's awesome. Don't do it.
All right, thank you all very much. If there's anyone who wants to ask any questions about any of our comments or anything, otherwise, good luck to everybody in the rest of the school year and in any other competition. Bye.
Thank you.
Thank you very much.
Thank you all for scoring and judging. Have an amazing day and an amazing weekend.
Thank you.
Thank you.
Thank you.
What he said.
Right. All right. Very good.
All right. Thanks, everyone.
Bye.
I
Good to see
definitely
you.
labeled their team name wrong. I thought it was Shuffle.
Yeah, I know who it is. Close enough.
Yeah, Lance and Sam figure that out. I'm sure they'll get it. Have a great day, everyone.
You too.